SJC-10332, Indeck, Maine, Energy versus Commission of the Division of Energy Resources.
Good morning, Mr. Dodge.
Good morning.
You may proceed.
Thank you. Madam Chief Justice, and may it please the Court, my name is Will Dodge, and I represent Ridgewood Renewable Power, who's the owner of the entities that brought suit against the Massachusetts Division of Energy Resources, DOER, for violations of the Renewable Portfolio Standard Program, alleging standing under the Regulated Industries exception. For over 60 years, this Court has found that competitors in certain industries have standing to bring lawsuits against administrative agencies based upon competitive injury. The types of qualifying industries have been quite varied. To be sure, banking, utilities, and insurance, but also some ones that are not so obvious, like bus companies, horse harness racing, and taxi cabs.
Do you rely at all on the point that, I mean, I sort of found it in your complaint, that yes, this is a competitive injury that you are alleging, but also that the area of concern of this statute is about promoting green energy, if you will. And that insofar as the other companies that got their SQs were alleged to have used D&C materials.
C&D.
C&D, okay.
Yes.
C&D, construction and debris, right. Materials, it was violative of the statutory purpose, right?
That's right, Your Honor. There's two purposes that we point to in the legislative history of Chapter 164. One is full and fair competition in generation, and the other is to promote energy production that is not harmful of the environment. So those are both two areas of concern in which we stand. But I think we didn't want to get into the whole question of environmental standing before we could even determine the much wider rule, the much broader rule, which is the economic harm rule that says normally you cannot sue an administrative agency based purely on economic harm unless the regulated industries exception applies. The real question before you today is whether to apply that same exception from the 20th century to an innovative, decidedly 21st century type of government program.
Don't we have to worry about the mootness problem?
Your Honor, we don't concede mootness in this case because the Division of Energy Resources didn't settle with us. We tried to enter into a settlement agreement.
Yes, but everybody, all four of these parties has their SQs and is proceeding with them, correct?
That's correct, Your Honor. But the underlying dispute that we're here before you today is exactly what we were arguing before Judge Van Gestel and was exactly what we were presenting before the Court of Appeals. I would say, though, that if there's any question about mootness, this Court, under its public importance doctrine, and it's what the Attorney General actually pointed to in the FAR application, says that this Court nevertheless has discretion to hear a case or decide a case that's of public importance, including when the parties have briefed the issue before you, where the failure to address the issue would create uncertainty.
We also have an appeals court decision out there, right?
That's correct, Your Honor.
So it's not as if this was settled before there was an published appellate decision.
You're correct, Your Honor. So we believe that that decision should stand. We understood the FAR application and the granting of the FAR application to mean that this Court wanted to be briefed on this issue, which is why
No, I don't disagree. That's what it meant. But I still think there's an issue about mootness. So I wanted to ask you this, though. Okay, let's just assume the appeals court, that this Court gets into the merits and the appeals and we come to the same result as the appeals court, which is what you're arguing for, right?
Yes.
The import of that result is the case should go back because the only issue dealt with was standing, right? It can't go back because it's been settled. I mean, I just find that troubling.
I understand, Your Honor. I think, though, that the question really here is, as I understand the public importance doctrine, as this Court has construed it in the past, part of what's looked at is there a possibility of uncertainty in the future as a result of keeping the decision in place of a court of appeals? And also, is it
this
capable
isn't
of
really-
repetition? And this dispute most certainly is capable of repetition.
It's capable of repetition, but it isn't so clear that it's evading review.
Well, the one thing I would say about that, Your Honor, is that for one thing, it took us a while to get here. For another thing, part of the concern of the statute is facilities that were in place or that were operating before 1998 and that made the investments, like our clients did, to ultimately upgrade them in order to participate in the program. It's not clear in the future how many more of those will still will still be operating, or if they might be changed over. So that dynamic between the existing plants and the new facilities, we believe, may in fact make it less likely that that a case like this will come back. That's based on one of the most important harms that our client is alleging, which is the fact of treating what's really old as new. But I would also say that even if this court doesn't believe the public importance doctrine applies, we don't believe that vacatur is warranted in this case, mainly because we believe, and I think the briefs show, that all sides believe it's a matter of significant public importance. Both sides are claiming that, on the one hand, the agency is saying, well, we won't be able to run our program if there is standing, and what we're saying is, if there's no standing to ever sue when the agency violates the statute and admits as much, then what incentive is there for anyone to invest in either existing facilities or, frankly, to go and build new facilities? And that really undermines the whole purpose of the program. So, again, though, we think that the public importance doctrine, as we've looked into it, for instance, there's a case, Local 1445 v. Police Chief, 29 Mass Appellate Court 554, in which, even though an issue was moot based on the public importance doctrine and it concerned standing, the Court of Appeals nevertheless heard the case. We think that's appropriate to do here.
Let's get to the merits, if we could, for a moment. The Commonwealth says that there is no regulatory industries exception, that that's simply one way to apply the area of concern test. Is the area of concern test not essentially a discernment of whether there's a legislative intent to give a right of a cause of action to a competitor? Is that a way to interpret it?
I believe that's correct, and I don't think it's as we see it, it's almost like three or a circle within a circle. That yes, you have to allege that you're in the zone of concern of a statute. No, you cannot normally, without some evidence of legislative intent to protect competition or to create a level playing field, allege injury purely on economic harm. But if you can show, and you must show it by looking at the overall purpose of the legislation in question, that there is an intent to protect competition, under those circumstances you can proceed as though you don't have to worry about the economic harm exception at all. I think fundamentally these two tests, on the one hand blocking or preventing cases brought purely on economic harm, and on the other hand this area of concern test applying, as I said, to 20th century industries in 20th century types of regulation, has been around for a long time. The only thing that's different, the thing about this particular industry, though, is here we don't just have an existing product and service that's being regulated. We have DOER issuing a certificate, a REC, a renewable energy credit, which is essentially like a currency that in turn the legislature has ordered retail suppliers to purchase from producers who are qualified to enter into the program.
But I worry that, and help me if you can, that your exception devours the rule. Because as I understand the competitive harm here is you're saying if they can do D and C and if they can avoid the vintage rule, they can essentially underprice us because it's more expensive to do what we do than what they do, and therefore people are going to buy their 1 or 2 or 3% from them as opposed to us. Is that the essence of your competitive harm theory?
I think the real question, the real harm is exactly what DOER recognized in their policy statement, which is if they let too many people in, based on the small number of competitors, they could undermine the price completely and wipe out the market and basically ruin the investments that we've made in existing plants as well as the ones that were, as well as creating new facilities going
But
forward.
the legislation didn't limit the number of persons involved in renewable energy. Indeed, the theory was, I would think, to increase the number.
Well, that's correct, Your Honor. But on the other hand, when you're in a business, you have to make a certain calculation based on how many people are likely to become a part of an industry as to whether it's worthwhile to make the investment. And based on that calculus of assuming this many new plants may come online, et cetera, and this is how many facilities are in existence as of 1988 or 1998, you make the investment accordingly. If DOER can just turn around that rule in the middle of the game, then we've lost some other opportunity that we should have taken.
But just to be clear, you're not saying there's a we got there first rule, that you're saying that we got there and then suddenly the market is now being glutted with these and we can't make any money and therefore they should bar them.
That's correct,
Are you
Your Honor.
saying that you could sue them on that ground?
No, we certainly can't prevent new facilities. If a new facility qualifies to come in, they come in. And we know that that's going to happen. And we, in fact, want to put into the ground some new facilities that will also be able to participate. But
You're just saying unfair competition in the sense of non-qualified facilities.
Exactly. And moreover, a facility like ours that was in operation in 1998 should be and a facility like Greenville and Boralex's, which were all also operating in 1998, should all be treated as existing, and you look at the increase in the existing generating capacity,
Well,
not
who
flipping it
decides
over
who's
and turning new.
qualified? Who decides who's
DOER.
The
qualified?
DOER.
Okay,
Your
well, did
Honor.
I understand you to say, in response to one of Justice Gantz's questions, that the government didn't limit who could come into the field?
Well, they limit through the criteria that they establish for
Okay.
what is considered a
Okay.
you know,
They
an
didn't set a
eligible
number.
biomass.
Right,
They
okay.
didn't
That's
set a
right.
number of
Yeah.
facilities
I
to
understand.
compete.
Exactly. So in that sense, it is a different type of program than some of the earlier regulated industries cases like maybe taxi cabs or some of the banks. What we also feel is important, though, is one of the arguments that the government makes is that this case is somehow different because we're attacking an individual decision as opposed to just a regulation in general. But in essence, we're doing both, and we honestly don't see what difference that should make as far as the regulated industries exception goes. The point is the whole inquiry is about whether there's been harm to an interest, regardless of what form that action takes. So that's so, and moreover,
But
what we're
a
trying
harm-
to do is
but a harm-
enforce the regulation.
But a harm to whose interest?
We believe, well, it's really a
Harm to the
two-pronged
government's
inquiry.
interest, or to your interest, or both?
It's a harm to our interest,
An economic harm to
an
you,
economic harm to
which
interest,
has
but
to match with a harm to the underlying intent of the statute.
exactly,
And that the harm to the underlying intent goes to the C&D stuff.
exactly, both to the CND, but also to
Oh, to the
basically
fair
a portion
competition.
between old and new.
I see.
And in fact, even though we've argued that we don't believe the 2008 amendments to the legislation should be considered in determining standing, they are important in showing that now the legislature has essentially said we find that there's an interest in keeping those 1998 facilities in place. That's essentially a recognition that many parties, not just Ridgewood, made substantial investments in those plants to make them comply with the qualifications or to obtain SQs, and that the Commonwealth has an interest in seeing those sustained, even though new facilities are coming
But
online.
isn't the consequence of what you're proposing is that whenever there is a credentialing process to determine who can be a competitor, any existing competitor can challenge the credentialing of another?
Well-
Because you say that was not a fair application of the rules, and you're unfairly allowing somebody to enter who shouldn't qualify.
Your Honor, you raise a good point, and the best example I can think of is the cosmetology case. Now, the cosmetology case was decided because there was a statute that specifically said you are not regulating the number or the contours of competition overall. But let's suppose it didn't have that particular proviso in it. It seems to me that it would have been very easy for a judge to look at the legislation and say, well, the intent here, yes, there's some licensing, but the real intent here has to do with public safety and making sure that cosmetology schools are teaching the right way, that they're providing good education, and that the licenses that come out of those schools are not just given to any old person. And it seems like a lot of the other regulated industries in the past, the Circle Grill case being sort of the paradigm example, just because a restaurant is opening under the street, it doesn't mean the zoning laws were intended to protect the existing restaurant who's going to be subject to competition. What's so significant about this particular case is the fact that the Commonwealth is controlling both the demand as well as the supply for the particular product, and that the product itself, as we've said, is this electronic certificate that's issued if you meet all the qualifications, and that it's subject to ongoing regulation. So we don't see that this is a floodgate, that this sort of turns every licensing scheme into a regulated industry. Thank you.
Thank you, Mr. Dodge. Ms. Shin?
Good morning. Assistant Attorney General for what is now the Department of Energy Resources. I will be splitting my time this morning with counsel for interveners, and we have agreed that I will take 10 minutes and my brother will take 5. In order to have standing under the area of concern test, Ridgewood has to identify a specific duty that the department owed to it and that the department violated. And
Well, isn't this, the judge below concluded this was not a regulated industry, but isn't access to the industry limited, regulated by the government?
it is only in the sense that the department applies eligibility criteria.
Well, correct. It's very important to the public that that non-qualified people don't go into this area, and the public is so dependent on it, so it makes sense. So how can we say it's not a regulated industry?
Well, it's important to the public, Your Honor, and that is not a specific duty that the department owes to Ridgewood. It's just a general interest that's important to the public, and this court has stated repeatedly that a general interest is not enough. The only... Sorry.
Finish your answer to Justice Cowan. Go ahead and finish.
I'm finished, Your Honor.
Where do you think the appeals court went wrong?
The appeals court went wrong, Your Honor, in not identifying anything in the terms of the statute, the legislative history, or in the overall regulatory scheme that evidences any legislative intent to protect the type of injury that Ridgewood is alleging in this case, and that the specific injury that's being alleged is the injury to its competitive position in the market.
Well, it also alleges that it's an injury to the idea behind the statute, which is to develop qualified renewable energy sources, right?
That's true, Your Honor, but again, I would submit that that's only a general interest in vindicating the purposes of the
what
statute.
happens if you've got somebody like Ridgewood, or you've got this statute, and DOER, and I'm not saying this is the case, but grants SQs to totally to companies that are using coal, the things that you specifically can't, coal, gas, they do it. Nobody can challenge that?
And my answer to that would be no, nobody could challenge that, because if the legislature wanted these decisions to be subject to review, it could have said so. And you know, I think agencies make decisions all the time that are immune from review, and this is because unless the legislature says otherwise,
agencies don't make decisions that are totally inconsistent with the intent of the statute that are immune from review.
That's true, Your Honor, but unless the legislature has said otherwise, we trust our public officials to execute their duties faithfully, and this is especially true in industries such as this one.
Well, I think that's a pretty weak lead.
I'm sorry?
That's a pretty weak lead. We trust our public agencies.
Well, the
I
department...
mean, the answer to Justice Botsford is we may trust them, but maybe there's somebody in the department who just doesn't understand that coal is actually not what we want to be doing.
That might be an extreme case, Your Honor, but again, you know, if the legislature wanted these decisions to be subject to review, it could and would have said so. Instead, what it did was it established a division within the department that has the special expertise in overseeing the installation of these new generating facilities. It's tasked with making sure that it sets forth policies that advances production, use of alternative fuels. And as an ENOS, this court should not intervene in the exercise of the agency's expertise. And the flip side...
I suppose, since the legislature enacted the statute, it could hold oversight hearings on whether the statute was being effectively implemented by the executive branch. Happens all the time, or used to in any event.
It could, Your Honor. And the flip side, of course, is that if standing is recognized in these types of cases, then any time a new facility tries to enter the market, it could be subject to, it and the department could be subject to potentially potential court challenges from the dozens of these
But the other side of that particular point is that if somebody is trying to do it right, and the let's just assume the allegations are correct, that the DOER improperly granted SQs to the two companies because they were using improper materials. Let's just say that that's so. So if there becomes a pattern of that, no one is going to go into this industry, because why do it? Why do it right when you can just cheat and get away with it?
Assuming that these allegations are true, and we would not obviously
I'm
not
not
concede that.
I'm not asking you to. But as a theoretical matter, it seems to me there is some value. You know, it isn't all a one-way street.
It's not a one-way street, but the flip side is, you say that you're an investor deciding whether or not to invest in the construction of new facilities, and you know that each time a new entrant comes in, right now there are approximately 75 to 80 facilities that have been qualified to participate in this program. And if you know as an investor that each time an entrant comes in, you're potentially subject to challenges from dozens of existing competitors, and perhaps,
You say in the bank case and taxi cases, there's something clear in those statutes that there was a right that the legislature meant to give a right specifically to other banks and taxi license holders?
Yes, Your Honor. All of those cases stand for the proposition that where you're talking either about exclusive licenses, or if the agency is tasked with determining the effects on competition, then a competitor would have standing to challenge an individual decision, such
I
as
have
the
to
one
say,
here.
when you read the factors that the appeals court lists, it certainly makes it sound like a regulated industry, right? When you read the factors on which the appeals court relied, it certainly makes it sound as if it's a regulated industry.
Well, actually, Your Honor, I think there were two primary factors that the appeals court relied on, and the first is that the department determines through its eligibility criteria who should be let into this program. And again, I would submit that that's no different than any agency that applies any sort of licensing or eligibility requirements. I think the second factor that my brother...
But unlike cosmetologists, at least, I don't know whether you'd agree with this, but the appeals court said you, the government, created this market.
And I would dispute that, Your Honor. This is not some artificial market that the legislature created. These renewable energy credits are generated throughout the northeastern United States as well as Canada. There are 4 other New England states that have an RPS programs, and so Massachusetts is really just one participant in this regional market. It has to compete for the credits along with the others.
That's missing the point. It's a government-created market.
It's created a minimum amount of demand that comes from Massachusetts.
Well, it's required that energy producers
Want to do this?
buy this stuff.
I don't
And then it
Right.
limits the people that can sell this stuff.
I don't want to
or
go
it
to a
qualifies.
cosmetologist because the government regulates it.
I'm sorry?
I do not want to go to a cosmetologist because the government regulates it, licenses. I don't want to go to a doctor because the government regulates it. I want to go to you because you, government, are going to give me, energy producer, something of value. And in that sense, it truly does create the market.
It creates a demand within, minimum amount of demand within Massachusetts.
I take it, do you agree, counsel said that there's no dispute that the agency violated the statute in granting these SQs and admitted as such? So is that a given here?
No, I would not concede that, Your Honor. What we were talking about under the old guideline is that pre-1998 facilities that were retrofitted with new technologies, under the old guideline, all of that capacity could be counted as renewable. And the department determined that since it's easier to retrofit rather than to construct new facilities, that to count all of the capacity as renewable would adversely affect the goal of developing new facilities. And so it changed the guideline to provide that only the increase from the historic capacity would qualify. But the point here is that...
But isn't that precise? I mean, forgive me, but that's precisely what Ridgewood is arguing. You know, that you create the market, you say for a minimum, you create, and then you tweak it every time you think, oh, well, it's easier to retrofit and it's less expensive, then I'm going to tweak it, because what I really want to do is create the supply.
And again, we're only setting the eligibility criteria. We cannot limit the number of people who come in. And the point is that, of course, the agency's decisions have some indirect effect on prices, and that the more supply there is, the more people you let in, it affects competition. And that's necessarily the case in all of these cases where the plaintiff is alleging competitive injury. It's saying the government has taken some action that has indirectly affected the market. This doesn't in any way equate to controlling competition. The department was solely concerned with how best to stimulate the development of new facilities in accordance with the express purpose of the statute. And Ridgewood's claim that it is somehow super regulated is simply not true in the real world sense. Generators like Ridgewood, as opposed to suppliers, are only regulated in that they have to meet the eligibility criteria.
But that's not exactly a simple proposition, is it? I mean,
in what way is it not?
it's a fairly comprehensive set of eligibility criteria that have to be met, aren't there?
It's just to determine who qualifies as a renewable energy source.
What are the consequences?
I'm sorry?
I'm sorry, I cut you off.
No, that's okay.
What are the consequences of allowing any license holder to challenge the application of a prospective license holder?
The consequences would be that the currently 75 or so facilities would be allowed to challenge each time a new entrant comes into the market. So the flip side of these decisions being immune from review is if I'm an investor deciding whether or not to construct a new facility.
Have you had, since the
I have to
appeals
take-
court, I forget when it came out, but has there been any challenge? What's happened since that decision came out?
June 2008.
As far as I know, there haven't been any challenges other than the ones brought by interveners against the plaintiffs.
Thank you, Ms. Shin.
Thank you.
Good morning, Mr. Whitaker.
Good morning, Madam Justice. Thank you. Good morning still. The renewable energy statute here does two things that are easy to understand. One, it tells people who provide electricity at retail in Massachusetts, if you're going to stay in business and be in this business of providing electricity at retail in Massachusetts, you will improve your mix of electricity. You will change the mix of the electricity that you provide over time to include less and less and less fossil fuel. The goal is not so much to enhance the consumption of renewable energy as it is to reduce the consumption of fossil-fueled energy for public policy reasons that the legislature finds.
Isn't one the flip side of the other?
So, yes, they are. They go hand in hand. But all the legislature is saying, if you want to be in this business, here's a quality standard you have to meet. If you want to sell refrigerators in Massachusetts, they have to meet efficiency standards. If you want to sell a car in Massachusetts, it has to meet emission limits and safety limits.
But what are the benefits of qualifying? If I qualify as a refrigerator, well, I don't get any benefit from the government. I may be able to protect myself from consumer protection. Do you get any benefits from the government if you qualify?
No.
None?
No, you just are able to conduct business. You're able to conduct business. The government says you can't sell refrigerators in Massachusetts unless they're so energy efficient. Right? The government is deliberately changing consumption patterns, but they're not regulating refrigerators. They're deliberately setting quality standards so that for anybody who does sell refrigerators in Massachusetts, sell gasoline with no lead, put food out that's meets certain packaging standards, quality standards, the government is always changing deliberately consumptive patterns for public policy reasons. And it's not regulating the industry when you tell an industry you have to improve your quality specs. That's the first thing this renewable energy statute does. And then it does one other thing. The purveyors of retail electricity in the state say, okay, how do I know that I'm improving my mix? How do I know that the electricity I'm getting is going to meet these
Stop and
quality
Shop
standards?
doesn't have to go, when it first wanted to open its first supermarket, it didn't have to go to a department of the government to get permission.
What's that?
But a supermarket that wants to open in Massachusetts doesn't have to go to a government agency, I don't think.
Yes, it does.
To get permission,
Absolutely it does.
permission to open?
Absolutely.
Okay, then it's a regulated industry.
No, ma'am.
Who do they
No,
go to?
ma'am. No,
Who
ma'am.
do they go to? Who do
No,
they
ma'am.
go
No,
to?
ma'am. Just because-
Who do they go to?
Just-
What agency gives them permission to open a store?
You have to, well, this is my area of expertise, but if you're going to bring in food and store it and sell it to people, you're going to have health and safety codes, so many hand washing stations.
Okay,
You're going to
but
have to
You don't
get,
have to get permission to go into the field, to enter the field.
no, you do have to have a license. It doesn't make you regulated. And that's the whole point of MAX, and that's why we stress MAX so hard in our brief. It said, look,
Well, the
Okay.
practice of medicine is not you have to have a license to practice medicine.
you do have, and
You have
practice
to
law
apply
for that matter, yeah.
and practice law. And if it's not a regulated industry, if somebody wants to be a doctor, can doctors come in and challenge the application?
No. We all have driver's licenses. Driving is in a regulated industry. The fact that just something is licensed, that you have to get an approval to walk in to the marketplace to conduct business, doesn't make you regulated.
Let me ask you the same question I asked Machinnon. If you say my answer's the same, that's fine. Where did the appeals court go wrong?
All right. Appeals court did two things fundamentally wrong. One, when they looked at this statute, they got a little dazzled by the second part of what the statute does. And I'll just complete my. First of all, it tells renewable energy. It tells providers at retail you got to improve your energy mix. It gives them quality specs. The second part of it dazzled the appellate court. It says, providers say, well, how do I know that I'm meeting my requirements? The legislature says, I tell you what, we'll set up a pre-qualification program so that generators around New England can come to the DOR, show them how they produce electricity, and if it meets the requirements of the statute, all right, they will be pre-qualified. And providers, retail electricity, if you buy from those pre-qualified entities, you can be assured that the renewable energy you're getting from them is meeting your quality standards. So it is a quality spec, which is it happens every day out there in the economy. Quality spec to the people who provide retail electricity, and then a pre-qualification program for people who want to supply renewable energy to the retail providers in this state. It's very mundane, but it is in a new area. It's never happened before in electricity, and that fact kind of got the appellate court running backwards, right? Running backwards.
Give me
What
an
we told
example.
them then.
Just
right,
give me an example of an old pre-qualification.
I'm sorry?
Give me an example of an old pre-qualification. You said it's in a new pre-qualification.
An old pre-qualification.
You said because it's electricity and it hasn't applied to electricity.
Oh, because it hasn't applied to electricity. Because electricity has always been electrons. It's always been vanilla. There was never any different brands or flavors of electricity. Now, okay, what the legislature did is we want more and more green electricity. An example, I can use the refrigerator example. I can use paper, okay? It used to be paper was paper. Increasingly, states are saying to sell paper in this state, it's got to have so much recycled paper content.
I understand, but I asked you about, is there any other industry where they've used pre-qualification?
Oh, sure. In fact, the state, for example, sets up on a website. It will pre-qualify all sorts of providers of goods and services whose quality specs meet the standards necessary for state agencies to consume them. So, for example, state of transportation. If you want to sell asphalt to the state of transportation, you have to go through a pre-qualification program, okay, in order to provide asphalt or cement or a variety of building
But that's if the state is purchasing, right? That's a little different than this.
We'll go to Max, cosmology. You want to run a cosmology school, hold yourself out to the public? You got to go through a pre-qualification process. You got to show us that you've got licensed personnel. You got to show us that you've got so many square feet per student. You got to show us that you've got boards. You've got to show us that you've got X gallons of nail polish. And Max was very clear that the regulations go into a great amount of detail about what you've got to show and pre-qualify before you can open your door and be a cosmology school. Okay? In almost any industry you can think of, you've got to show some modicum of qualifications before you can open your door and hold yourselves out to the public. Doesn't make you a regulated industry. All right? This statute is 1.5 pages long. It does two things. Quality specs for people selling electricity at retail, pre-qualification. Now, That's where they went wrong. They got dazzled by that. And then they did this. And Chief Justice, this is the second place they went wrong. They then went to the case law, which is the area of concern test, and completely mucked it up. For the first time ever, they laid out 5 criteria, 5 indicia of a regulated industry no one had ever seen before. No one's ever seen them before. All they had to do was apply MAX, was apply the area of concern test and apply MAX. And that MAX stands for one thing, which is this. And Justice Gant, you pointed it out. In order to be within the area, to be within the regulated industry exception, you got to have a right, a privilege, and immunity, something the legislature's given you that a court can treat with. You can't just allege competitive harm. You have to stand there and say, the legislature's giving me a special right. And I'm wrapping up right here with my last sentence. The legislature's giving you a special right that you have standing to protect. A special right, a special interest. Nantucket Boat, special interest, special privilege, franchise, exclusive right, some protection from the normal course of the competitive marketplace that the legislature has bestowed upon you. If you don't have that, you don't have any stand because there's nothing to protect.
2 sentences.
Thank you very much, Chief.
Thank you, Mr. Whitaker. We'll take a short break.